I understood everything he said. I object. What are you then going to give him permission to post on his YouTube about me?
Jeremy Hales here, citizen journalist on the beat in the street at the creek for WTH News. And what's going on? Hearing number 3, where Judge DeThomasis denies all of LIEnette's motions, the same motions that incriminate her in a defamation case. More to come on that. That'll be breaking news. Right now, what's breaking is this court case. And all of a sudden, out of nowhere, a bomb threat is going to be called in.
What that leaves us with, let me get to it a second, is what Respondents' Counsel filed, which is on 12/29/23 at 4:24 p.m., what's entitled Notice of Supplemental Authority, that authority being the Budlove decision, which is cited at 49 Florida Law Weekly D50A, a second DCA opinion issued 12/29. And I've been saying 4 days ago, but when I read it, it was 4 days ago, right. 6 days ago now.
My lawyer filed a motion to change all of the temporary injunction because this judge, DeThomasis, took away my legal freedom of speech, my First Amendment right. And not only mine, yours, everyone's, because he said anybody associated with me. Now, I doubt she grasped this or understand that, but that even means LIEnette couldn't even speak her own name on social media, on any of my videos, on any platform whatsoever. He took away the world's freedom of speech, whether the majority of the world live in the United States or not. That's what this man thinks he has control of. The planet! And what happened days before is the state of Florida came out and said, you cannot touch protected freedom of speech. Now, what's protected freedom of speech? It's what I'm doing right now. I can say anything I want about LIEnette, as long as it's covered under protected freedom of speech. For example, unprotected freedom of speech, you can't run into a movie theater and yell fire and create chaos and create a scene unless there's an actual fire. You can't sit there and go and say things like LIEnette has said, I'm going to crucify him to a cross. I'm going to nail him to a cross. That's actual physical harm. She stated that over and over again. So has Crook. Now, we've never said anything along those lines. Called her a liar, and as long as it's true, there's no problem. Called Crook a rug dealer, and as long as it's stated as truth, there is no problem. And who stated it? It was LIEnette. So now we're fighting to get all of ours protected First Amendment rights back. Freedom of speech.
That the court
the motion filed the same day as the opinion.
I'm sorry?
The motion was filed the same day the opinion was published.
I got you.
12/29.
The court's received and reviewed that. Obviously, judicial notice is taken of case precedent. It includes a motion to amend the extended temporary injunction, primarily addressing the language of the addendum, and a requested to take judicial notice. So to the extent requested judicial notice is granted, the notice of supplemental authority doesn't need to be granted or denied. The court has knowledge of that opinion. With regards to extending or modifying the extended injunction, let me say the following. So the decision reached by the Second District Court of Appeals on December 29, as I said before, was of no great surprise to this court, and in fact, from this court's perspective, mirrors quite a bit of what the court discussed of record on 12/6/23 in this proceeding.
It simply amazes me that Judge Craig DeThomasis can say that this mirrors what he had talked about. This is the man that literally took away First Amendment freedom of speech. This is the man who's sitting on a seat that is supposed to protect constitutional rights. And the exact opposite is what happened. So there is no mirroring of what he said or what he did. He's looking at a law right now that says you cannot take away freedom of speech. It is protected by the Constitution. It didn't mirror what he did or said in the court. It's the exact opposite, polar opposite of what he did in the court. He not only took mine, he took everybody who's associated with me. Anybody who's watched a video or seen a video. We have over 250 million views.
In that, this court brought to the attention of the litigants that the statutory change of October 21 and added additional language, that including the phrase, quote, directly or indirectly, unquote, and the phrase directed at, quote, or pertaining to, unquote. Those 6 words were commented upon by this court. They were commented upon in the footnote of the Strober versus Harris, issued January 5, 2022 by the 2nd DCA at 332 Southern 3rd, 1079. This court also, as stated in the most recent 2nd DCA opinion, most specifically, as I mentioned before, but it's worth saying again, in the concurring opinion of the Chief Justice, that the court needed to narrowly tailor so as not to infringe on the rights of the respondent.
So what did he do? He actually infringed not only on my rights, the rest of the planet's. This is what we call black robe syndrome. This man thinks he's all powerful and can do anything. And in that courtroom, he does hold the power. Outside of the courtroom, he has no power whatsoever. And he's never had any power over you watching or what you can say or what you can do. But what he's trying to do is hold me accountable for what the rest of the planet does and says. This is why I think it's pretty important at this point to get Channel 20 in the courtroom, to get the local papers, the Chiefland Citizen, to get all of these individuals that are true journalists. They are true media press personnel, because he will hold them accountable and put injunctions on them for anybody who watches the news story, anybody who reads the news story, and then contacts somebody else or says something. Do you understand? This spiral is out of control. Where does it stop? If he holds me accountable for everybody on the planet, who is he going to hold accountable for the news and for the paper and for every other platform of media in the world?
And specifically with regards to that, at 56 minutes and 34 seconds into the proceeding of 12/6/23, this court said the following. The language that the court would propose would be, and I read, orally pronounced, what was the court's inclination of proposed addendum to the language. Everybody heard that. Everybody was asked to consider that. At 57 minutes and 39 seconds into that proceeding, the court, in response to counsel's comment, was kind of a consensus that really that language as proposed was I use the word stretch. I mean, this is a broad definitional pronouncement of the definition of cyber stalking as amended in October 21 by the legislature. But the court also said that it was the court's intention that the court, trying to narrowly tailor it and not to infringe on his other rights to communication and or speech, except as it relates to this person or individual, i.e. this petitioner, Ms. Preston. That was the statement of the court. The court took a break. The court provided that language for consideration, and at 1 hour, 3 minutes, and 21 seconds, counsel for the respondent stated no objection to the language you proposed. At 1 hour, 5 minutes, and 0 seconds, respondent's counsel, in response to the court, stated we do not object. At 1:06:15 seconds, the court stated, I'm going to add the language, read again the language that I went and typed on the break and brought it to the court's attention. Again, no objection, no question, no clarification, no modification, acceptance. And then on top of that, because it was the court's obligation, and I prefaced it with Mr. Hales, I'm not suggesting you're gonna violate the terms of this, but you're entitled to know, and here I am telling you that a violation could result in prosecution, could result in contempt, etc. Understood? Yes, I understand. And then we walked away. And
what you're hearing is a judge trying to cover himself for what he did. He took away my First Amendment rights. Now, as he states over and over again, no objection, no objection, no objection. I want to be very clear. You can't hear it on the microphone, but I'm upset about the entire thing, and I'm objecting to the entire thing. But I hire a lawyer to represent me. If it were me, I'd object to absolutely everything he said and done. But my lawyer's telling me, listen, now's not the time. There is a time and a place for this battle and this fight. And right now, it's temporary. It's okay. It doesn't affect you, but we're going to deal with it, and we're going to deal with it at a later time. So yeah, I'm objecting, but my lawyer is unbiased and is not emotionally invoked and involved in it as me, and can say, okay, I know it's not what it should be, but we're going to battle that later. And not only is it going to be a battle, at this point, I think it's going to be ending up a state war.
so to the extent, and I want to hear from you, counsel, to the extent that you feel that this opinion should change or modify, it's a request to modify the language, to the extent that you feel this opinion should modify what the court's belief on 12.6 was already the intent, maybe I didn't carry it through, that may be your objection or your argument, to narrowly tailor it by not directing Mr. Hales to take down anything prior to that date, but to prospectively follow the language in the addendum. And so what is it about that language that you think, in light of Budlove, is not narrowly tailored? And again, what Budlove does is reverses the second DC. It upholds 5 injunctions against for protection against stalking. It upholds the findings, but it reverses on the language of the injunctive relief being too broad.
Right.
It doesn't tell the court, it says what's too broad, but it doesn't say what would be narrowly tailored. It's given the trial court the obligation to invest the judicial labor to narrowly tailor it.
Well, Your Honor, on page 7, I think it does. At the bottom, injunctions which, quote, prevent communications to, unquote, an individual can be permissible under the First Amendment. Communication to her, but this is social media. No one's being, she has to watch the video. She has to subscribe to his YouTube account to watch it.
Yeah, but hang on, read
Okay,
the rest
then
of
it says
cites
those
to
in-
David.
I object. I do not have to subscribe to
It
watch
cites
his
to the
videos.
David decision, which the second DCA says we're in conflict with, and we wanted to certify it to the Supremes.
But yes, but Judge, there's no first DCA opinion in conflict here, so therefore this is effective. This language, I'm saying this is a clarification. This is an important opinion. I can go back and read the briefs. I'm sure there was arguments on both sides saying that injunction in this case, the Budlove case, which really matches yours, was constitutional and consistent with the statute. I'm sure there's arguments on both sides, Judge. Until we had this clarification, that's what appellate opinions do, Your Honor.
So give me a set. So again, the court's oral pronouncement on 12.6, which was reduced to writing, which was not objected to, is there not a distinction that there's waiver?
Oh, I don't think any litigants or even trial courts can waive the Constitution of the United States.
I hope you understood the gravity of what my lawyer just said. You can't just wave off. You can't just knock out the foundation of our country, the Constitution of the United States. Not only that, the very First Amendment, freedom of speech. And this judge just wants to go,
The David opinion, Judge, was when the old statute. That was under the old cyberstalking statute.
Which the
So what they're doing
concurring
is,
opinion of the Chief Justice says really is inapplicable because it was interpreting a statute that didn't include 6 words that included directly or indirectly or directed at or pertaining to.
right, which is why this judge, I think her name was Justine in Pasco County, her ruling was consistent with yours, her injunction had the same language. there was no objection there either, because this is a new statute. You pointed it out. This is new law.
And so let me pull up the language that's in. I guess my question is, what are you suggesting should be the limitation or the modification? The motion is to modify the language. And so just for the record, so that's clear, the protection involved in or implicated in the extended temporary injunction for protection against stalking issued 12-6 is the standard language of the Florida Supreme Court form 12.980 subsection U, with the addition of what's called addendum, which is attached to and made a part thereof, and under subsection 5 of the order enjudged, it says, please see attached addendum, and the court added the additional language. So what is it about those two paragraphs that the court wrote and included as part of the injunctive relief needs to be modified? I guess I'm inviting suggestion.
An injunction is simply a no contact order. We don't contact LIEnette. We don't contact Crook. We don't want them anywhere near us. We don't want any communication with us. We don't have a problem with don't contact them. We've already blocked them on every platform that we have. Now, we understand that they're going to continue to make problems for us, and they're going to break the injunction. So we went ahead and unblocked them. Because how do we know if they actually broke the civil protection order trying to make contact with us if we have them blocked on everything? So we went ahead and unblocked them. That way we can report it when they break that civil protection order. But we have no desire whatsoever to have any contact with them. We're not going to communicate with them. And a judge is not above the constitutional amendment of freedom of speech that he has completely and taken away.
It's almost a gag order. You can't go on Facebook or anywhere and mention her name. You can't mention her name, show her image. You can't do anything. That's overbroad. That's not narrowly tailored. That's what it says. You can certainly, the other language, the fighting words, incitement, these words, these are unprotected, and so and also any kind of communication to her is everything else in there is standard. This new area of gagging someone, basically saying, if you go on YouTube, Facebook, TikTok, whatever they got out there, and say her name or anything about her, you're enjoined. That is a prior restraint on constitutionally protected speech. And given the conflict with the new statute that the legislature changed, this indirectly, that language, wow, it opens up a Pandora's box. So I think the other opinion is wrong too by saying you can't do that. No, you can narrowly tailor it. You can't tell him what he can say what he wants. No, you can't. There's certain, he can't threaten her. There's certain fighting words he can't do. That's still enjoined. But this blanket is overbroad, Judge. If he basically went on YouTube and said, by the way, there's an issue of what her legal name is, but Michelle, whatever, said her name, he's now subject to criminal violations of free speech, which is constitutionally protected. I think the opinion is very important.
So, two things. One is, Bud Love, as you know, is a case where parties and or litigants and or people brought into a piece of litigation in a looked like a Chapter 39 termination proceeding.
Something like that, yeah.
Those participants were being commented about in social media. And ultimately the court said as to those 5 persons that they were being stalked, and this DCA upheld the stalking injunctions. So it's a little bit different in that the basis of this petitioner's complaint is that the postings themselves, so those were postings about a court case. Bud Love is postings about a court case that led to be considered stalking. This case is about the postings themselves being a large part of inciting and fomenting others to act, and that's the pertaining to. It's posting about her in a manner, this is how it's alleged, this is how it's pleaded, it's posting about her that's mostly causing, it's not limited to, but it's mostly causing other people to act upon of persistently, consistently following, videotaping, writing about, which included threats construed as possible harm, possible violence, financial consequence of disastrous consequence to her and her non-for-profit, labeling her child abuser, a criminal, etc. So it's like it started that the nature of the communication that was being published was the basis of the injunctive relief, not that it's that the postings grew out of another piece of litigation. Now, what we don't know is what's the trial court going to do when Budlove et al. Gets sent back to the trial court. And so, number one, in that context, I'm asking you, and the second part of it, or 1A of my question to you is, what are you suggesting would be, given that I read, my intent was to narrowly tailor. My intent was to not infringe on constitutional rights. I did that in the previous temporary injunction. I did that, in my opinion, in the addendum that was not objected to.
And to be clear, the case that they're talking about were social media people. There was a divorce. There was all kinds of nasty, nasty, horrific things said, okay? Now, the difference with this is we just broadcast the news of our lives. And this liabetic person stalks us to Otter Creek and then devastates everyone around her. And we tell you the truth. DCF, Children's Services, it goes on. And everybody has the right to report when they see something wrong. Now, at no time have we ever said, all right, everybody uprise, we're going to go storm the villages. No, not at any point in time. Budlove is a whole different monster and a whole different beast of complete and total inappropriate words, complete and total inappropriate fighting, and unprotected speech. Everything George and I have shared on What the Hales has been the story of our life with protected speech. Constitutionally protected speech. And at the same time, we have always, from the beginning, said, don't contact anyone or do anything. We will handle it legally.
And so to the extent that this opinion may change your client's view and your view about this, I'm asking what would be, or you're telling me the whole thing is overly broad?
No.
Tell me where it is.
It's just, he should be allowed to post, he should be allowed to.
The injunction is going to tell him what he can't do.
I understand.
I'm not going to tell him what he can do.
Well,
that's for you as his lawyer to advise him that based on the court's ruling, you could still do this, but the court's ruling says you cannot do that. If I'm going to enjoin, which I have, the court's order is going to read what he can't do. And so right now it reads, based on the totality of the circumstances presented to this court in prior pleadings and in the form of evidence presented to this court on 11/29, and based on the extension of the injunctive relief, etc. So it goes on. It is therefore ordered and adjudged that in addition to the conditions and restrictions previously imposed, which is the standard, so that first paragraph really doesn't do anything to enjoin. It just simply says why we're doing this, why the court's doing it, and so it's the second paragraph. The respondent and or anyone under his control employed by him or in any way under his direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that he does not publish in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and or likeness, and or any information, data, photography, videos related to and or pertaining to the petitioner and or her minor child. So it's that paragraph, if you're suggesting is overbroad, what would be narrowly tailored language?
Okay, thanks, Judge. At page 9 of the opinion, it's right there. We can substitute Budlove for the word Hales. But at the bottom, in this case, the injunctions granted against Budlove Hales do not merely prohibit Budlove Hales from having any contact with the petitioner, sending communications to the petitioner or causing others to send communications to the petitioner or inflict some manner of harm against the petitioner, those are fine. In addition to preventing any contact with or communications to the petitioner, the trial court ordered that Budlove Hales cease communicating publicly about the petitioner, ordering that he refrain from, quote, posting online anything related to her case.
Wait, anything related to her case?
But that involves the individuals, Judge. That's what they were doing. It's not just the case. The individuals, in fact, if you keep reading the order.
Well, the word anything, I guess, anything related to the case.
In other words, the injunctions, they said it. In other words, the injunctions, on page 9 to 10, in other words, the injunctions prevent Budlove Hale from engaging in public speech about a court proceeding and the individuals involved. This content-based prior restraint on speech is not tailored at all, much less narrowly tailored. The prospective prescriptions on Budlove Hale's social media communications are, for example, not confined to constitutionally unprotected speech, such as fighting words, quote, those personally abusive epithets which, when addressed to the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. True threats, those statements the speaker means to communicate a serious expression of intent to commit an act of unlawful violence, and those are alleged, Judge, I follow you, to a particular individual or group of individuals, or incitement communications, all of these things. To the extent the injunctions broadly prohibit him from merely making public statements about the petitioner or her case, the injunctions are overbroad and impermissibly enjoin a constitutionally protected course of conduct. It cites the statute and crap acts. So I would just say we could just mirror this language. He's enjoined from this, however, he's not enjoined from constitutionally protected speech. Something like that, it would be fine.
This is a serious issue. I hope people grasp and understand that George and I literally right now under this judge could go and get a temporary injunction or a permanent injunction against Marla Hughes because of everything she's posted, because of everything LIEnette has posted. From Angela Gleason, because of everything that she's posted and done, because of what LIEnette has posted. From Paul Hembry, for everything he has posted, because of everything she has posted. Literally, everybody who claims to be a supporter of her, we could now go and get an injunction under this judge based off of what he's saying, based off of what he's already done. We can get injunctions on everyone out there who continues to post, and we have screenshots of all of it every single day. And then when these individuals break the injunction and continue to post, then they have a criminal record.
So I'm reading in the second paragraph of this court's addendum, which is part of the injunctive relief. All right, so the respondent and or anyone, etc., from utilizing any media platform related to and or pertaining to the petitioner and or the minor child.
Mm-hmm.
So one way to remedy that, if you're suggesting, I'm not necessarily agreeing or disagreeing, would be and or pertaining to her minor child, which is also named in the injunctive relief here being sought.
Yep.
That it could go further to say pertaining and or pertaining to the petitioner and or her minor child that may be construed as fighting words, personally abusive epithets, which when addressed by the ordinary citizen are as a matter of common knowledge inherently likely to provoke violent reaction, and or true threats as are those statements where the speaker means to communicate, etc. And that paragraph out of Budlove could define, I can tell you this, your client's still at risk because that whatever future behavior he engages in or language he behaves in accordance with would then need to be construed as, does it meet that constitutional definition or not? But that's for somebody else to decide. But what you're saying is, I guess I'm hearing what you say, is that the language is currently in the addendum could remain so long as we add Because right now it's a broad, you can't do anything, info, data, photography, videos related or pertaining to the petitioner and or her minor child.
You could probably hear me talking to my lawyer. Those microphones are really powerful, and I'm objecting to everything, especially because this judge likes to bring up that he's made decisions, and my lawyers, both of them now, Mark Feather and Randy Shockett, have not objected. And I'm going, object, object. He's going to bring it back up again, and he's going to say we didn't object. Now, my lawyers' jobs are to keep me calm, and my lawyer's jobs are to keep my emotions out of it, okay? And he's telling me, listen, Jeremy, it's going to be okay. Don't worry about it. We'll take care of that at another point. And he's got the ultimate big plan while I'm focused on the judge is taking my rights away again right now while he's fighting to actually get them back for me.
And I'm suggesting that if we add, that may be construed as fighting words, which are those personally abusive, et cetera, et cetera.
Constitutionally unprotected language, right.
That may be construed as constitutionally unprotected speech, such as.
And you can cite, I don't think anything wrong with the order citing Budlove, but.
Well,
yeah.
I could,
Yeah.
and I would, because I think I'm required to, because that is the status of the law, despite, and I keep going back to the concurring opinion, but I understand 2 versus 1 to win,
Yep.
even within their, that, as pointed out by the concurring opinion, I would say that, and I'm going to look to it. It's not a dissent, it's a concurrence.
Right.
However, it includes, quote, however, I disagree with the majority's assertion that in determining what is or what is not constitutionally protected activity, the court should focus on whether the communication is directed at the individual seeking the injunction or whether it merely pertains to the individual. It's a criticism of that finding or that portion of the finding, and then goes on to say, because it's based on the David decision at 189 Southern 3rd 871,
Which was the old statute, which is the old.
which interpreted the old statute, and then concludes with, in effect, I would certify conflict with the 4th DCA's David line of cases that suggest the bright line rule on a prohibition of prior restraint.
Well, that's the great,
So-
I think, yeah.
But nonetheless, the concurrence concludes, and I quote, I conclude the trial court could enjoin Budlove from making future statements about the petitioners that incite others to violence against the petitioners, regardless of whether those are directed at the petitioners, without also violating First Amendment rights. However, the injunction right now could be construed as preventing Budlove's posting anything at all. There's two ways to go about it then. One would be to cite to the language previously mentioned, which is in the opinion of Budlove, or the other is to simply say what it currently reads and then just add limited to future statements about petitioners that do or may incite others to violence against the petitioners, regardless of whether they're directed at the petitioner. I don't know which one creates potentially more problems, but I think I'm inclined to go with the more specific and just take the language right out of it.
That's fine, Judge. Thank you.
Any idea how much this is costing me? Hearing after hearing after hearing. And all we're truly ever hearing is LIEnette and Judge Craig DeThomasis, and they're costing me tens of thousands of dollars. And just this hearing on this injunction, when it's all said and done, I'm guessing is going to be roughly $150 out of my pocket. And then there's civil and other actions going to be brought against, actually already have been brought against LIEnette and CROOK as well, for defamation and perjury, and it's going to keep going on and on and on, just like the judge does. Just take the words and don't infringe on somebody's legal rights.
Your Honor.
So I'm not, Ms. Preston, I'm not denying you opportunity to be heard. I want to hear from you before,
Okay.
I want to get through their version since it's their motion. So, to the extent that you could follow, on December 29, the second DCA ruled on a case which
I understood everything you said.
affects potentially the language that this court added to the Supreme Court approved language that was already in effect. My intent was to not infringe on his constitutional rights. The argument is being made to the extent that I intended so. It may not have come to pass that way because this decision now says, with similar language in that case, that it was too broad, and it remanded it back, saying to the trial court, come up with different language that's more narrowly tailored to not infringe on such rights. And they're asking the court to do so by adding language that would now limit. So it says, right now it reads, you can't post anything about Ms. Preston or her kid. Very broad. And what they're asking is that it say,
He wants to
to
still
the extent
be able to bully me, belittle me, humiliate me, and make money off of me. And that's what he's doing. And in turn, his fans on their hate groups, which I do not have, but they do, says, let's kidnap a child, let's Baker Act them, so that then we should be able to get their child taken away. All of this is coming from everything he says.
so if he did that, and I'm not ruling on it because it's not an issue before the court, but it's more likely than not that if the posts were in the future about inciting others to commit acts of violence against you or your child, which could now be considered a felony, violent felony, very likely that would not be constitutionally protected. That would be constitutionally unprotected as being construed as fighting words.
Am I the only one in awe that this woman stalks us to Otter Creek, then creates Facebook pages, then attacks not only us, but almost every single resident of Otter Creek on these pages, then is found guilty, and so is CROOK, in the state of Ohio, and then is now claiming that we have hate pages. We don't have hate pages. We share truth. We share reality. We share what she has said and has posted publicly. We share public information. We never incite. We never share hate. We only share truth and reality of what actually has happened and what is happening or what is potentially going to happen because of it, such as there will be another case for defamation based on what she did, posting signs that said I was the Ohio rapist. That's reality. And this woman is so far from reality, and so are the individuals that continue to support her. It's my constitutional freedom of speech that is protected to be able to say that.
Or considered personally abusive epithets, which, when considered or addressed by the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. So Mr. Hales would still be precluded and admonished and proscribed and enjoined from saying such things.
Then let me ask the courts, what are you then going to give him permission to post on his YouTube about me?
I'm not giving him permission to do anything. I'm denying him permission to do certain things within the parameters of what the Constitution allows.
And what, so what
So
does,
let me I'll paraphrase it. I don't need to read you the quote.
No.
I could list for you in the next 2 minutes probably 15 cases. You guys are neighbors to a great extent. I know we got an Ohio connection, whatever, but what came out in evidence is he's a neighbor of yours by virtue of his property, because I had to address, yeah, but while you got to drive around the other way, even though your properties are closer.
And they don't.
So you're neighbors. There are a dozen or more cases that say for whatever reason, the injunctive process is not designed to keep people from being uncivil and to prevent people from being rude and from keeping people from being unnecessarily and unwanted boorish behavior towards another citizen who happens to be their neighbor. There's not a good solution for that. Not in injunctive court. There may be in another civil proceeding, but not in injunctive court. It's all about violence.
Right.
Any language construed in the future that would provoke violence when addressed by the ordinary citizen as a matter of common knowledge, inherently likely to provoke violent reaction, he'd be committing a violation of the injunction.
So
Take notice coming up, Rex the bailiff, who's an incredible bailiff. I actually really like the guy. He's got a good sense of humor, good sense of reality. He just exited because a bomb threat came in, and then he's going to come back.
And so the
Under the
court's
court-
intent would be to proscribe and prevent and to enjoin him from certain things, but I'm not going to tell him. His lawyer might give him advice. I don't give advice of what people can do.
Did Judge Craig DeThomasis just say he doesn't give advice? That's the only thing he has done in 3 hearings so far. For LIEnette, not for me.
every time they film us, every single time they come up to us not going to them coming to us, filming us, like John walking on a walker down the road. No one's around. We got a neighbor we're talking to. I'm on the phone with an advocate. He drives up screaming, 10 feet, 10 feet. You're violating the 10 feet. See, people, he's violating it. He's turned it into Ohio. And now we are facing charges of contempt of court for things we are not doing.
Give me 1 minute.
And here we have again, under oath, admission of guilt of breaking the civil protection orders. And yeah, it's going straight up to Ohio. And now you see Rex going straight to Judge DeThomasis. There's a bomb threat.
Giving him the ability to do that.
Okay. So here, hold that thought. I'm going to just take a brief recess. If you guys need a comfort break, we're at 10:49. We've been going
Yeah,
since
I need
9.
to change a diaper.
Why's the judge not doing anything about a child out in a vehicle, locked in there for an hour and a half so far, with somebody who she claims is an abuser, at 4 years old, needs to change a diaper, even though LIEnette a year ago posted that she doesn't even wear diapers. Those diapers that were found ditched and dumped on Dead Dog Road, those weren't hers. Nope, those weren't hers. Anybody think that there's more of a threat for the child than there is in this actual bomb scare? As a matter of fact, LIEnette has brought up the aspect of kid napping. They're sleeping, okay? I need to use it more appropriate for YouTube, okay? And it's not a lack of freedom of speech. YouTube has their own policies, and we appreciate their policies. And so, as a matter of fact, she claimed her own mother, kid, and was sleeping for 15 years, her own. And then Marla Hughes had quite a bit to say about that as well. As a matter of fact, this is going to come up in court. Marla is going to be in court. So LIEnette is saying her mom was kid sleeping and her sister was kid sleeping for 15 years. And it's actually Marla Hughes who's inciting fear, not what the Hales.
All right, let's take 15 minutes.
At this point, all buildings were evacuated, and the victim's advocate, Amanda Martin, famous, who has property for sale right across the street from her right now, George and I are looking at it. She then gets really nasty with myself, with George, and then our attorney as well in the restaurant. And Russ the Sus is nowhere to be seen. But don't worry, this hearing isn't over yet. And yeah, it's explosive.